we see it often. A company will go out, they're working off of tax rolls, for instance, or working off of a software that gives them a surface owner's name, and they're working largely off of just what the landowner has told them. Oh yeah, I own this. This is mine. This is me and my wife's, or whatever the case may be. And we see agreements drafted based off of, information from the tax rolls and word of mouth from the landowner. And what we also see in some of those instances is, as you move down the line, well, Brent Broussard doesn't own it. It's in the Broussard family trust, or it's Brent Broussard and his brother own it in undivided interest. And again, we talk all the time about opportunity loss. Well, you've spent all this time thinking you've got a good deal, when come to find out, now you got to go back to them. And every time you go back to someone, the wallet has to come out. It's just the nature of things. It will cost you. So, what we're looking for in that initial title run from on the acquisition phase is a good source deed, a good deed that properly describes the tract of land that you're securing. And then we're ensuring that the caption of the agreement, which means the grantor, is properly and correctly entered and included in that agreement, such that when you sign that agreement, you've got a marketable contract in your hands. You've got it signed by the right person. You've got the proper description of the lands included. And beyond that, you're going to start to pick up an idea of any surface tenants, any more recent activity that affects the surface that may be relevant to your transaction or your project that may not be visible yet on the ground. It's going to help you identify pre-existing rights. So that's the importance of doing like that step one abbreviated cursory review. So Natalie, once you've done that, take it to the next step.
So once we've done that, we know that this person owns the surface, then we're able to go ahead, get the contract done. And then my next suggestion to the client is, hey, let's go ahead and start looking at the minerals ownership. Don't kick this can down the curb. They don't all listen to me. But I try really hard to protect them as much as I can. It's important to go ahead and look at that early on, because a lot of times what I see and what the trend has been is for them to go and secure their title commitment policy, and then they get the policy, the preliminary policy worked out. They have surface title run, and then all of a sudden it's this panic rush to go and get secure surface waivers. And I've had clients come to me with their title commitment and say, hey, I have this commitment and it references a couple of different mineral reservations in here. Can you go get surface waivers from these people? They're the mineral owners. And I'm like, whoa. Those deeds are 40, 50, 60 years old. You don't know who the mineral owners are. We need to go run that title and then decide based off that title who the actual mineral owners are to get the surface waivers. Yeah. And that gets really hard, because a lot of times by the time it gets to us for that, if they use that model and we don't do it on the front end, then we're up against their option agreement deadlines. Mm-hmm. They may be towards the end of their deadline to execute, and it may leave us 3 months to go run title and secure all these surface waivers. We don't know how many there's going to be underneath there, right? Yeah. So it's doing it earlier on in the process, and ideally doing it at the same time that you're getting your surface title commitment is the way to go, because you can look holistically at the whole picture at that point and really decide, you may have a great surface area, but you may have 150 mineral owners.
You may have garbage minerals below it. I think, right. Natalie, let's step back. I'm trying to, again, always try to remember and think that we're trying to just talk to someone who's brand new to this space. So
sure.
Let's explain, typically in a title commitment, what you see with respect to minerals in a title commitment. You hear it referred to as exceptions. What if you're a brand new, or someone new to the renewables business, and you're a developer, you're working in the real estate group or whatever the case may be, and you get a title commitment put on your desk? Typically, what do you see a title commitment? How does it address the minerals?
So it's when they're running the surface chain of title, if the examiner does this, they're supposed to, but again, we're humans, right? So if the examiner sees a mineral reservation in the chain of title, they're going to note that in their run sheet, and then it's going to show up as an exception on the title commitment. That means that they are notating that there's been an exception somewhere in the chain of title for minerals. That does not mean that that mineral exception has been run fully out to present.
Yeah.
So just because you see the exception on your Schedule B or whatever it may be, okay, that does not mean that that is the current mineral owner. That deed that they're seeing could have been from 50, 80 years ago. And
100
those
years
minerals
ago.
could have moved, yeah, 100, yeah. Those minerals could have moved through many different hands.
Yeah.
So,
And I think further
yeah.
to clarify what you see there, that's just an exception saying that this commitment does not cover the minerals, and it's subject to these reservations that we've observed, although they do not certify that those are the only reservations in the chain of title that affect the surface. It's important to understand the work that's done in a title commitment on the surface side. It's very much they're pulling an abstract from title cards, and title companies historically, their only concern has been surface transactions from person A to B to C to D all the way through as it pertains to the breakup of the surface. Oftentimes, if you have mineral conveyances from, a mother to a child, say, I'll give you all my minerals, whatever, that's not tied to a geographic location at times. You see all these things. So that title commitment is essentially accepting and excluding the mineral breakdown, the mineral examination from that commitment. That's where the work that a landman kind of comes in. That's where the mineral, that's the important part about it. Natalie hit the nail on the head about a title bomb. You can have a great surface project. It can check all the boxes as far as connectivity, development possibilities, favorable contracts, whatever. But that mineral ownership can break up and be very complex. You could deal with working interest owners, E&P companies. This happens all over the country on these projects. So those are things that are important. That's really important to understand what's included in your title commitment. And part of that process is that we see it's companies realize that this commitment does not include the minerals, and they only know to do the minerals because the title underwriter at some point after they've had this thing on their desk for 6 months tells them, oh, you've got a mineral exception, you need to do mineral title. And again, we always hit on opportunity loss and de-risking. What opportunities have you lost not knowing about what's exposed to you in the mineral side of things?